SJC-13754, Thomas Galvin versus Roxbury Community College.
Hey, Cromack.
Good morning, Your Honors. May it please the Court. The Superior Court's order allowing Mr. Galvin's motion for partial summary judgment included at least two separate errors, each of which provides an independent basis for vacating the judgment. First, the motion judge erred in ruling that Mr. Galvin established as a matter of law that he had a reasonable belief that a violation of the law had occurred, which is a state of mind issue on which he had the burden of proof. And second, the motion judge erred in ruling that Mr. Galvin was not required to prove that he was acting in good faith. This is not the exceptionally rare case where it can be ruled as a matter of law that the party with the burden of proof has sustained that burden. Neither side has pointed to any case where summary judgment has ever been granted to a plaintiff on a state of mind issue on which they had the burden of proof.
If reasonable belief is an objective standard, well, let's start with that. Do you think that reasonable belief is an objective standard or a subjective standard?
I think there's two parts to that. There's the employee has to have a belief, and then and that's subjective, and then you evaluate whether that belief that he has is objectively reasonable.
Okay, so if the reasonableness piece of that would be objective?
Yes.
Okay, so in this circumstance, at least it appears to me from the summary judgment record that it was undisputed that as of the date plaintiff made his report to, I forget what the group was called, that a violation of the Clery Act had occurred. That as of that date, there had been a violation of the Clery Act, at least one. Am I correct that that fact is undisputed?
No, Your Honor.
Why?
That fact, it's not clear from this record because Mr. Galvin crimes have to be reported under the Clery Act if they are reported to a campus security authority. Mr. Galvin is a campus security authority. So if somebody tells him about a crime, he is supposed to report it.
But it had been reported prior even to his arrival there, no?
Yes, but
Okay.
Mr. Galvin never designated anyone else on campus as a campus security authority.
I'm not talking about any of that, okay? I'm talking about whether it was undisputed that as of the date he made the report, a violation of the Clery Act had occurred by Roxbury Community College. Forget individual which employee, just by the defendant.
Well, but that's what I'm trying to explain is that we only have an obligation to report crimes if they're reported to campus security authority.
So you're saying there would be no evidence that it had been reported before to a campus security official before the date he made his report?
Correct. Now, there is evidence that it was reported to other people prior to that, but Mr. Galvin is supposed to publish an annual security report that designates.
I'm not talking about his individual shortcomings because the reporting obligation is on the entity, right? It's on Roxbury Community College. Now, you may choose to have a particular person or another person do that, but the obligation is Roxbury Community College's, correct?
Well, the way the regulations are set up, yes, but Mr. Galvin is the lead campus security authority, and so he's the person we've designated to make those reports.
Okay.
So, and then he's supposed to designate other people and inform them of the obligation.
So you're not disputing that he failed to do it by the date he had made the report?
That is not necessarily correct, depending on which version of events you believe, Your Honor, because as of the date he made the report, we know for sure that he knew of it as of November 2010. So the first time that would be reported would be in the October 1st, 2011 clery report, which is still 2 weeks in the future at the time that he makes the report. So it's clear that once he doesn't report it in October 2011, that there's a violation. Before then, on this record, it remains a question of fact as to whether it was reported to a campus security authority, because Mr. Galvin never designated anyone as a campus security authority and never published a, and this is in 34 Code of Federal Regulations, 668.46, subsections, I think it's A, B, and C are all relevant to this question, but it kind of spells out who can be a campus security authority. And for an example of how this is done properly, in the record at Appendix 4, subsection 212, there is an example of how, or I'm sorry, not page 212, there's an example of how you would designate that. So the people on the campus know these are the people to go to with reports, because we don't have an obligation to report it all across the campus for if anybody receives it. It's only if certain designated people receive the reports, or if the Boston Police Department received the reports. That's how we're supposed to track it under the law. And so it becomes a violation after Mr. Galvin, but it's not clear that it's a violation before then on this record, because it's not clear, as a matter of fact, who the campus security authorities are besides him. He may be the only person who has that obligation.
He has predecessors, right? What about the old ones? So this woman reports this sexual assaults to people well before he's hired, right?
I think.
Don't they have, so there's no responsibility of reporting those things, because there is a campus security officer somewhere, right? I mean, if they fail to report it to the campus security officer, that's not a violation?
That under the clery regulations, that's what the clery rules, the clery regulations say is a violation. You don't, I mean, it might be a best practice to have other people do it, but it is not a violation of the law unless it's reported to a campus security authority. But you only get to that question if you can rule as a matter of law that Mr. Galvin has a particular belief.
Well, but you see, that's where I have some legal, the reasonable belief, the good faith belief protects erroneous. It protects you when you're not correct, but you have a good faith belief. I don't believe it applies when when there has been a violation. Whether you don't need good faith, meaning he may be covering his own tracks. That's why Justice Wojciechowski's question is so important, because I think you're taking a good faith which protects erroneous decisions and applying it to correct ones. I don't think that's right. Any cases that say that? Because it seems like you're flipping the standard. You're making it, instead of it being more protective of a whistleblower, you're making it less protective of a whistleblower.
Well, I agree that it is appropriate to use it in your context, and no, I'm not aware of a case. If I was, I would have cited it. But that is how the statute is written. The employee reasonably believes. It could have very easily been written to say it violates the law.
That's because it's tracking all of these retaliation statutes, which are designed to protect, again, reasonable but good faith mistakes, as opposed to Justice Wojciechowski's point, which is if it happened, you know, we're not concerned. I mean, he may very well be covering his own errors, but that's a different issue.
And again, Mr. Galvin testified, even if we believe it is a state of mind issue based on the way it is written in the statute, employee reasonably believes. And I agree that it is frequently used to.
I thought yours was very clever, but I've never seen it done. I've never seen it interpreted the way you're doing it.
It may very well be, though, that it is a rarer case like this that someone would be reporting on their own, reporting something that they testified that they didn't believe, and reporting something that is really their own area of responsibility. Mr. Galvin is the lead campus security authority, and so it's his job to report crimes that come to his attention, and it's also his job to inform people that they have an obligation to report to him to the extent they do, to the extent he wants to designate them as campus security authorities. So if he testifies, I didn't know whether this was reported and I didn't believe that it was possible to find out, but then he writes, this has been failure to report, he made a correct guess, but he didn't believe it at the time, and that's based on his own testimony. I would agree in many cases this is a
Well, I
minimal
I
requirement.
read the testimony, and I don't think that's what it actually says. What it says is he didn't know how to report it.
It also
Can you give me a page reference in the record to where he says he didn't believe it occurred?
So he testified in, this takes too long, may I submit a letter? I'm going to try to, he testified to two things. One was that he didn't know how to report it, but before that he testified that he didn't think it was possible to find out. And I know we addressed
Didn't
this in our
find out
brief
what?
insight to it. Huh?
Didn't think it was possible to find out what?
It was possible to find out whether it had been previously reported. He claimed that his office had been, all the physical
Okay,
files
but
had been
that's
removed from his
something
office.
different than what you just said, unless I misheard what you said. You said he didn't believe it had occurred.
He didn't know whether it had been reported or not, and didn't believe it was possible to find out. He also didn't know, once if it had not been reported, how it should be reported. So he,
Okay, well, it might be helpful to submit a 16L letter with the precise page references as to what you claim raises a disputed issue of material fact as to that he didn't believe that, I guess, the offense had occurred.
but again, Your Honor, I will do that. I appreciate the opportunity to do it. But Mr. Galvin is the party with the burden of proof here. So
Sure, but basically, this goes back to something that Justice Kafker alluded to. It seems to me entirely possible that in the case of a statute designed specifically towards public employees, that the legislature would be seeking to encourage the reporting of unlawful activity, even by those employees themselves, that it would not preclude that from coverage of the statute.
I guess we don't agree with that interpretation, and it's hard to square that intent with subsection F of the statute, which requires, which is the waiver and exclusivity provision, which says you waive any other possible claim if you bring a whistleblower claim. And so it actually evidences an intent to make sure that you only bring a whistleblower claim, which has enhanced damages and attorney's fees and other things, when you truly have a whistleblower claim, and that it's not just thrown in other contexts.
So is that another way of saying you can't whistleblow on yourself?
It's not as a matter of law that you can't whistleblow on yourself, but that goes to whether it is reasonable for him to be making the report. Whether it's objectively reasonable for the person in charge of clery reporting to be saying, other people who I've never trained in clery reporting have failed to make this report. I personally have asked the Department of Education, they don't know what to do with this report, and it's fine for me not to report it. That's why I don't report it in October 2012. I am doing my job. These other people who've never been trained in clery reporting, they have failed. That's the part that the objective reasonableness and whether he's acting in good faith.
The judge left that. The judge, I mean, it's a very fine parsing of summary judgment of like elements. I'm not seeing that kind of thing where we're doing elements of, as opposed to a claim, but the judge leaves to the trier of fact this issue whether he's, what the cause of his firing was. Was the cause of his firing because he was a whistleblower, or was the cause of his firing because he should have fixed all these problems and he didn't? He left that to the jury, didn't he? Or himself? I can't remember if this is a bench trial or a jury trial.
It was a jury trial, Your Honor, but that's still a separate issue. Whether there was a causal relationship between his termination is different from whether he has done the things that the statute requires him to be a whistleblower.
The judge didn't find that he had done everything he was supposed to do. The judge found he was a whistleblower. And whistleblowers are often people who've been pressured into doing things for a while, and then they finally stand up. I mean, whistleblowing, you're sitting there in an organization and something's going on. You don't always immediately, run to the Boston Globe and complain. So I'm not sure what the judge did here, which is very sort of refined, is
The way this court's ruling in Pardo described it, essentially, there would be very many cases where it would be reasonable under these circumstances to make this report, but that's not the only outcome, because sometimes it is used as a smokescreen by the employee.
But wasn't that left to the I totally get it. This guy was in charge of this stuff, and at least some of the time he hasn't done, at least according facts in the light most favorable to you, but that's left to the jury. The jury, and I haven't read the closing arguments, but I assume you stood up or in court and said, he's the guy. He was the one responsible for all this, and he didn't do it. He's just covering his own tush.
We weren't able to say that latter part, because as a matter of law, we definitely said he was terminated because he wasn't doing his job, but we weren't able to say that last part.
You weren't able to say that he was the person who was responsible for reporting all of this, and he's whistleblowing on himself. You weren't allowed to say that?
We weren't allowed to say that this was covering his tush, as you said, because the court had already ruled as a matter of law that it was not, that it was a report that he believed as a matter of law, and that it was objectively reasonable as a matter of law, that there is no circumstance where it would not be reasonable for Mr. Galvin, the person in charge of Clery Act reporting, to be reporting on other people who he'd never told about it, instead of helping to solve the problem himself. So there's some overlap, but it's not entirely an overlap. There's three elements to a whistleblower claim, and this is the judge excused the plaintiff from proving the first essential element of a claim based on a state of mind.
Can I ask you one question? It seemed a little unusual that we're doing summary judgment on elements of a claim as opposed to a claim. Are there cases like this where we grant summary judgment on an element of a claim as opposed to a whole claim? It just seemed strange to me.
I agree that it's strange, but it does sometimes happen. I don't think that's a basis for our appeal, but it's certainly strange for it to happen on behalf of a plaintiff in any case where they have a burden of proof. It may, Mr. Galvin had a story to tell here, but so did Roxbury Community College, and we were prevented from telling it with respect to whether he actually believed the things he said, because he testified that he did not, and whether he actually, whether once we determined what it is he believed, whether that belief was objectively reasonable. The legislature could have very easily used a written report to something that violates the law or that he reasonably believes violates the law. But the way it's written, he has to reasonably believe it before he's entitled to the protections of the whistleblower statute. We don't want people making bad faith complaints, lying about people.
If it's actually occurred, we want whistleblowing to happen so that illegal conduct is aired. Do we care whether, and we're also willing to err on this side of having whistleblowing that's incorrect to protect proper whistleblowing. I don't know the opposite, that we would tolerate, that we don't want whistleblowing by bad people who are not, that just seems inconsistent with the whole purpose of whistleblowing.
I suppose the concern would be we don't want people whistleblowing on themselves rather than fixing the problem themselves, or trying to blame other people for their own responsibility and using the whistleblower law as a smokescreen, as the court was concerned about in Pardo. We want to make sure that they are not just trying to, Mr. Galvin makes this report right when he when he knows that the state auditor is going to contact the Board of Trustees. Before then, he just had questions about what to do with it, but then he makes an accusation. And the inference from that is that he's thinking, I'm not going to be the one who gets blamed for this. He was fine telling the DOE and the auditor that he didn't know what to do, but he wasn't going to tell that to the trustees. So what he determined to say is, this is somebody else's fault, not mine. But it's not clear that it was a violation of the law at that time. It became a violation of the law 2 weeks later when he did not report it.
Can you just clarify to me exactly what it was you were precluded from bringing forth at trial?
Sure. Well, some of it's prudential because the court has ruled as a matter of law. So we know if I'm trying to say Mr. Galvin didn't believe this, our fact section here, a lot of it is about him not believing the things he reported and whether that's reasonable for him to be reporting it, separate and apart from, whether the reasons he was fired.
So you weren't allowed to articulate that he didn't believe.
He didn't believe these things. It was his, he was.
He didn't believe what things?
He was not acting in good faith, and he didn't believe that the report had not been determined. We rely on Mr. Galvin to determine
Did not
this.
believe that the report had been what?
That the report, he didn't believe that the report had or had not been made yet. He had no information on that. He didn't think it was possible to find out. He also thought that the proper course, based on
And you were precluded from articulating that.
yes, and that he was, the whole volume of anything related to whether he was whistleblowing, how he came about to make the report whistleblowing reasonably and in good faith is out of the case now. An essential element of a case that's an essential element of an analogous 151B claim. And
Is that right? Were you really precluded from that? Because I have the same question Justice Wendland has. Were you precluded from arguing that when he made that statement to the board or whoever it was, that I know you're precluded from, the judge found that to be whistleblowing. I get it. Did he also say that you were precluded from saying that he was covering his tracks and he is the person responsible? Were you precluded from making the argument you just said before, which is we don't want whistleblowers using the whistleblowing statute to cover their own errors? Were you precluded from making that argument, or were you just precluded from saying this filing was not whistleblowing and he was doing it for malicious reasons? It's the precision of that may matter.
well, that is not in the record. We don't have the entire, at least in the appendix, we don't have the entire transcript. But I know that in the end, there would have been no hook for that argument because the jury has already been told that if we had made that argument, the jury has already been told that that argument would be wrong. And so we self-limited because the jury was told.
Has the jury been told this is whistleblowing? This is a whistleblowing activity. And based on this record, it's whistleblowing. But you're free to show we fired this person because he's responsible for the reporting relationship. He's responsible for protection of safety on campus. Weren't you allowed to do all that?
We're allowed to say we fired him because he wasn't, for the reasons stated in his termination letter.
Including that he didn't handle this process properly.
Correct.
So you were allowed to do a lot here.
But the jury was told at the beginning that he made a report and engaged in protected activity as a matter of law and was therefore
Were
protected
they
by
also
the
told that he made that report in good faith, or were they just told he made a report that's a whistleblower act?
I believe, and I'll defer to the transcript, which I know is cited in my statement of the case, is that he was told there was no mention of good faith because there was no agreement that that was a requirement.
Isn't that important?
No, Your Honor. It was an essential element of his case. The jury was told that he had already proved it, that he was a whistleblower, that he engaged in protected activity under the whistleblower law, and that they were to only focus on whether we fired him because of that, and that specifically he was told that the letter to the trustees was protected conduct as a matter of law. And so any attempt to undercut that would be the opposite of what the court had instructed. And so we really couldn't, as a prudential matter, make an argument that was the opposite of what the court instructed the jury at both the beginning of the case and the end of the case.
Let me just ask if there are any further questions. Thank you, counsel.
Thank you, Your Honor.
Attorney Brown.
Good morning, Justices. May it please the court, I'm Orestes Brown for the plaintiff appellee, Thomas Galvin. Justices, Judge Kirpilani in the lower court got it exactly right. Where the activity complained of by the employee is conceded to be unlawful behavior, no further inquiry is needed because he has satisfied the objectively reasonable belief standard necessary.
Because he just stood up and said they didn't concede it. And they've got, I mean, it's arcane, but he's got a way of saying that it wasn't a violation. Was that presented to the trial judge, the motion judge?
They did concede it, Your Honor. They concede. The judge makes a
Is
footnote.
it in the record somewhere? Because that
It is in the record, Your Honor.
It would be nice if you have that handy. Do you have that handy?
I do, in the record appendix. In the judge's decision at footnote 33, the judge makes note that when Thomas Galvin complained to the trustees of RCC about the alleged wrong, the RCC conceded that he was complaining about wrongdoing. That's number one. But number two, the defendant, RCC, lied.
Wrongdoing is kind of a moral concept. Was he complaining about a statutory violation?
Complaining about a statutory violation. And Your Honor, more importantly, the facts of this case are uncontested. It was uncontested at summary judgment, uncontested at trial, and it's uncontested in the pleadings before the court today that this whole case began with a series of sexual assaults that occurred between 2000 and 2006 before Mr. Galvin was hired to be the director of safety and facilities at RCC. In 2010, Mr. Galvin, through a student who alleged to be one of those victims and had returned to school, became aware that
I'm just trying to be precise, because Justice Wolhojan's question really is very important to me.
Well,
Is there evidence that those sexual assaults were reported to the person who has to report them under the Clery, or is that a misinterpretation of the Clery Act? I'm not an expert on the Clery.
No, Your Honor, it wasn't a misinterpretation of the Clery Act. After Thomas Galvin made his complaint, first, of course, he went to the Department of Education. Second, he went to the state auditors. How many times do you have to complain? He went to the state auditor's office. It's all in the record. Then he went to the trustees. And the judge, Kerpelani, said, for a variety of reasons, that it wasn't until he complained to the trustees in September of 2011 that he was actually complaining about definite wrongdoing, and that issue was conceded. And it was conceded not only in the pleadings by the defendant RCC, but it was conceded in all of the admissions in the O'Connor-Drew report. RCC had commissioned not one, but two independent studies of what the problem was. The first was the O'Connor-Drew report, which RCC submitted summary judgment and relied upon heavily, and was consequently their admission about what had happened. An O'Connor-Drew report stated specifically that sexual assaults had occurred in from 2003 to 2006. They had not been reported, and that the failure to report these by RCC was a violation of the Clery Act. That's in the report. There's also another report that went into the record. The
By
independent.
the way, O'Connor, they're accountants, or are those the lawyers? Because there's a lawyer's report separately from this, right? O'Connor they're accountants, right?
They're accountants.
So I don't know what are we going to get comfort from when we read that, or are we going to have to look at what the lawyers said?
You'll get, well, the O'Connor-Drew report specifically finds, the language in there is that the sexual assaults that happened in 2003 to 2006 were reportable offenses and required reporting under the Clery Act, and that the failure to report those were a violation of law. That is clear in the O'Connor-Drew report, and that is backed up by the independent counsel report as well. Worse, the independent counsel report, which comes into—
So that would be as of what date?
I'm sorry?
In my mind, it's important to know whether there was raised a triable issue of fact as to the date on which the violation occurred. The violation being the failure to make the Clery Act report. So I take it is there something in the summary judgment record that we're going to find that says, as of such and such a date, RCC was in violation of the act?
I believe the O'Connor Drew report states that, and I believe the independent counsel report that was done.
And so what was that date?
Those reports were done in the O'Connor.
Not the dates of the reports, the date on which the Cleary Act was not complied with.
It was not complied with, I believe, between 2003 and 2006, when the actual sexual assaults occurred and RCC became aware of them.
And just to put a finer point on it, because opposing counsel had said, even if somebody at RCC knew about it, only the CSAs, I think they're called, are the reporting officers under the Cleary Act. So there's something in the O'Connor report that says the CSA at the time knew or was aware of it? Or am I misunderstanding the?
Well, Your Honor, under the Cleary Act, every certain type of administrator at a college or university
So it's just wrong that somebody had to designate you as a CSA in order for you to be a CSA.
I believe
everybody
yes.
At the college knew and there was a CSA who fit these various categories.
That is correct. That is wrong. For example, the director of, I believe that certainly all the administrators of finance, the administrators of human resources, I think Paul Alexander, they are automatically designated reporting authorities under the statute.
And is there a provision you could cite for that? Or is there a provision that we can look at for the automatic designation? Because that's, again, very important. Because I take it this young woman reported this to, was it the provost? I can't remember. Who did she report to in 2003? And she reports to someone very high up, right?
She reported to Elena Shanks, who was Thomas Galvin's immediate boss, who was had her position in 2003 and 2006, and I believe was the person who fired the alleged sex offender.
Okay, and just the provision, and that would be helpful in at least a 16L letter. If you don't know the answer to it, the provision that makes you an automatic Cleary reporter, if you don't know it right off the top of your head.
I don't know it.
You might be getting the answer right here.
So at the Rule 56 hearing, RCC admitted it had not reported the student's complaint of sexual assaults in 2003 or any time before Galvin's employment, and conceded that it violated the Cleary Act, and that is an appellee supplementary appendix at page 27 through 31 at paragraphs 136. At pages 27 through 31, and then at page 136, paragraphs 5 through 6, and again at page 137, paragraphs 3 through 11.
What are you reading? What are you reading from? Are you reading from your brief or are you reading from a decision?
I'm reading from my brief, Your Honor. I'm reading from page.
That's not helpful.
No.
I'd like if you can give us a 16L letter giving us the legal, the statute or the regulation that makes these high-level administrators Cleary Act reporters, that would be useful and necessary, I would say.
Are you asking me in follow-up to today's hearing? Yes, absolutely. Thank you. Thank you, Your Honor. But if I may continue, the justices are correct that, assuming it was established and conceded by not only their admissions, but also by their pleadings, that RCC had violated the law from 2003 and 2006 by failing to report these sexual assaults, it is therefore determined as a matter of law that Mr. Galvin had a reasonable belief that the law had been violated. You don't really have to go any further. And the justices are correct that in every case involving state of mind, reasonable belief is used to expand the protections of the Whistleblower Act to protect whistleblowers who have mistakenly alleged that a violation of the law is concerned. As long as they've had a reasonable belief, they still enjoy those protections. So you're right, the argument is opposite from what the Attorney General is presenting you today.
But the argument is, and I'm not saying I buy it, but the argument is that unless there is some sort of subjective state of mind as to the reasonableness of the belief, that one could cover yourself as the violator of the Clery Act by reporting my own violation.
Well, the attorney.
So I guess I'm just giving you the opportunity to respond to that counter argument.
Yeah, and so the Attorney General in the reply brief brings up the example where, I think that people are generally aware there was an issue with a state crime lab where one of the scientists had doctored the results, but yet
So why would the legislature want to protect that kind of conduct?
Because I think, as one of the justices already said, the interest in the whistleblower, the Commonwealth and the Whistleblower Act is to, under any circumstances, to encourage employees to come forward to expose employer wrongdoing. We don't want public agencies.
And so the cure, perhaps, for that rather odd result is that the employee who reports his or her own misconduct might not be able to show that he or she was terminated because they were a whistleblower. They were terminated because they engaged in misconduct.
Well, if the law, so
Is that right?
yeah, and so so if the law is broken by a public employer, the Commonwealth wants, under any circumstances, a public employee to come forward and say, hey, you're breaking the law. That's the primary concern. And it doesn't matter whether that employee is a poor performer or has actual malice towards the public employer.
No, but it might matter that they are the person who's engaged in the misconduct, or corporations operate through their employees, right? So there is somebody who's engaging in misconduct. And I guess I understand the argument that the Attorney General may be wrong, that there is no reason why you would protect such an employee as a whistleblower. But the countervailing argument is that they just won't win, that they were terminated because they whistleblowed, right?
I'm not sure I understand the question, but even if the employee is involved in illegal conduct themselves and even has participated in it, the Commonwealth still wants them to come forward and report wrongdoing by the employee, and they would enjoy the protections, but they would still be dischargeable because
So what protections would they enjoy if they're still dischargeable? What is the protections of the Whistleblower Act?
well, you're protected from retaliation, but that doesn't protect you from being discharged for other legitimate reasons.
Right, like you were the one engaging in the misconduct.
Right, exactly. So, which is exactly what the Attorney General.
What about this situation where an employee falsely reports for malicious reasons, just in bad faith, let's say, it doesn't have to be malicious, that another employee at the public employer broke the law? And that report is false, that whistleblowing report is false. Could the employer terminate that person for making the false report without engaging in retaliation?
Yes, if there's,
How?
well, you don't get the protections of the whistleblower statutes unless you can show you had an objectively reasonable belief that a law has been broken. So if you falsely report somebody, I take that to mean they are reporting a crime or or an unlawful behavior that did not actually occur, then you don't enjoy the protections. So you don't get designated as a whistleblower. In this case, Mr. Galvin was designated by the whistleblower as a matter of law because it was conceded that he was correct, that the law had been broken. There isn't any question either in any pleadings. The RCC and the Attorney General have never taken the position that the law was not broken by this non-reporting. As a matter of fact,
They're saying that because of the judge's decision on summary judgment on that element, it somehow tainted their ability to make the defense that he's the reason this thing got out of hand. Were they prevented at trial from doing, because we're going to read this whole trial transcript, you know?
absolutely not. And I believe that
They were allowed to argue that he's responsible for all of this. He's covering his tracks. He's blaming other people for what he should have done. They were allowed to do all that?
yes, Your Honor, and it's absolutely clear from the in the appendix record appendix, we put in their motion for new trial where he goes through that. They got the benefit of making that was their entire case at trial, that really it was Tom Galvin that broke the law. As a matter of fact, they didn't argue that the reporting requirement, that violation of the reporting requirement was not a violation of the law. They argued that, yes, those sexual assaults had to be reported, and then they argued that it was Tom Galvin that didn't report them. That was their entire case that they tried to sell to that jury, and which was rejected by the jury.
Can you just, because that just doesn't make sense to me. And it doesn't make sense to me because if it were stipulated that the Clery Act was violated prior to Mr. Galvin's role as the reporter, why would the trial judge allow that argument to be made? Why would the trial judge not handcuff the Commonwealth in the way that the Commonwealth said? Because that just doesn't make any sense. So on the facts before the trial, they say, okay, we concede that the Clery Act was violated, but then we're going to allow them to argue that, well, he's just trying to cover his own tracks because it was violated before he was responsible to report it.
The trial judge allowed it. And as a matter of fact, and I think it's in both our briefs, it's certainly in our brief and it's certainly in our appendix that the trial judge, despite the ruling by Judge Carpellani, even allowed an examination of Tom Galvin's state of mind. He said specifically, I'm going to allow everybody 5 minutes to examine the witnesses as to their state of mind, including Thomas Galvin. So I can't get behind the judge's reasoning. It was a very difficult trial, but that is in the pleadings, and I do remember that, and that the Attorney General had every opportunity to—
When you say in the pleadings that's included in the record appendices?
Yes, Your Honor.
Can you let us know exactly where that, you don't have to do it now, but that would be really helpful.
Absolutely. I will follow up and submit that.
He's asked if there's any further questions. No, counsel.